Everyone applying for a visa must have an acceptable standard of health. For some, this can be a real make or break for their application. Hi, I'm Simon Laurent. I'm the principal of Laurent Law, which is a specialist immigration law firm based in Auckland, New Zealand. We've been operating since 1996, and we provide specialist assistance to all types of visa work, as well as other more complicated immigration problems. And it's our particular business of solving those problems. One of those is the issue of medical waivers for those who do not have an acceptable standard of health. Now, I'll give you a little bit of context here. For short-term visas, the issue of health doesn't usually raise a concern, and it doesn't even come into the picture. However, if you intend to stay in New Zealand for more than 12 months on something like a work visa or applying for residence, then you are required to do a medical certificate. Now, in completing such a medical certificate, you have to be found to have an acceptable standard of health, or ASH for short. Nowadays, immigration receives the medical certificates by way of its online e-medical system, and there are a set of nominated panel physicians around the world who are allowed to do these. You can find these on the Immigration New Zealand website. There's a map even to show you where they are, and the doctors upload the data they collect in the examination to the online system. This goes through to the health assessment team. Now, medical problems are usually identified by the panel doctors themselves, who will flag these for the HAT, the health assessment team, and indicate that the person may not be of an acceptable standard of health. Now, sometimes people think they've got a medical issue when they actually haven't, and they are all clear. More often, however, we see situations where people are not aware of an underlying condition until it is identified in the course of the medical examination. So, what to do if you're not ASH? Well, there is the possibility of getting a medical waiver. However, some people are not able to access this. For example, most temporary visa applicants, that's visitor, work or student, cannot request a medical waiver, except for a few exceptions. One is for business personnel who've been seconded from within their company to New Zealand for a short duration, and in that duration it's assumed that they may not become a risk to the New Zealand health system. One other exception is partners and dependent children who, under their particular categories, are eligible for a medical waiver even if they're applying for a temporary visa to work or study here. Now, in the course of residence, there are certain groups of people who are also not eligible for a medical waiver. This includes people who have been diagnosed with TB, those who need dialysis treatment, and those who have a quote-unquote severe, or a physical, intellectual, or cognitive, or sensory incapacity which requires full-time care. Now, the kicker with this is that full-time care can mean anything more than 4 hours a day. So that full-time does not necessarily mean full-time in the way you would normally expect. This can be a difficult hurdle to cross for some people who may have an intellectual impairment, for example. So let's talk about the waiver process. And we're going to focus here just on residence because this is where it usually rears its head. Now, if a person is not ASH, this means that there's a relatively high probability that they are going to cost the New Zealand Health Service a lot of money. Note that definition, relatively high probability. I'll come back to that. Now, there's a list of conditions which are deemed to cost a lot of money, such as HIV, hepatitis B and C, heart disease, dementia, and so on. But some of these are only not ASH if the condition is deemed to be severe, such as for severe heart disease, ischemic heart disease. And this matter of severity can be a real bone of contention. If the condition is not on the list, then it will still need to be looked at as to whether it is chronic or acute. Now, if it's a chronic condition which is ongoing and may last the rest of the person's life, then the question is how much it's going to cost for ongoing treatment. The magic figure is 41,000 New Zealand dollars. So that if a person with a chronic condition is going to cost the taxpayer $41,000 or more for the life of the condition, then they are out. That, of course, could be difficult for anyone to meet who has a considerable health problem, which is going to need some ongoing medication, for example. The other category is those who have acute conditions, those that may last a relatively short duration or require relatively short duration treatment, but that treatment is going to be expensive. The test for this is whether that condition is going to, or has a likelihood of costing $41,000 in treatment within the next 5 years. Now, if someone has a condition of this nature, it can be very important to get a specialist opinion, which will actually set out prognosis of how likely it is that someone would require some kind of intervention in a certain period of time. And we try to insist upon people getting such reports if their specialists are able to do so. Another group who may be found to be not ASH are children, in particular children who need what is called Ongoing Resourcing Scheme Funding, ORS. This is where they may have developmental needs which will require remedial assistance while they're at school, so that if they're applying at school age or before school age and they're coming for residence, they could become ineligible for a resident visa. And more importantly even, if their application is declined for that reason, then their whole family's application is declined if they're coming with parents and other siblings, so that some of the toughest battles can be fought over whether the child actually needs ORS funding or not. And specialist paediatrician reports can weigh in favour of such a finding, but are often strenuously opposed by the medical assessors who have a different opinion. Now, there are several stages to the medical waiver assessment. The first is that the immigration medical assessor will send their conclusions to the immigration officer considering the application. And the applicant then has the opportunity to supply further medical information which may dispute the medical assessor's findings. Once that has been provided, if provided, then it goes back to a second medical assessor who also acts as what they call a medical referee. That medical referee's finding and recommendation is deemed to be final. The immigration officer tends to adopt the medical assessor's final finding, although in my opinion the immigration instructions don't require them to do so. However, that is what happens. The next stage after that is that if the medical referee has determined the person is still not ASH, then the applicant is given an opportunity to make submissions as to why they should get a medical waiver. And a medical waiver essentially means the possibility of a decision being made to grant residence despite the medical condition. Now, the criteria that are applied in considering medical waiver are set out in the immigration rules. And there are a number of things that a visa officer is required to take into account, and they include the following. First of all, the objectives of the category of visa that the person is applying for. For example, if it's a family-based application, the importance of bringing that family member to be reunited with their relatives in New Zealand. Secondly, there's the degree of cost which the person may incur because of their medical condition, balanced against other contributions that they may be able to make. For example, if they're highly skilled, they may be in a well-paying job, which is going to generate a lot of taxable income, which may offset the cost of the treatment. That argument, you would think, ought to work quite well. Unfortunately, it doesn't seem to carry as much weight as you might imagine. Next, the person's family connections in New Zealand. If the balance of their family is in New Zealand, that can weigh strongly in favour of a medical waiver being granted, and vice versa. Now, people often argue also that they are able to afford to take out their own medical insurance to cover the costs of their treatment. However, this doesn't carry any water, unfortunately. Now, there are two reasons for this. The first is that a medical insurance policy could lapse or not cover the condition properly. And secondly, and really this is the more important one, is that New Zealand is obliged to extend its public health services to all residents and citizens, irrespective of any arrangements they may have made for their own private medical insurance or medical care. And this is a rule which is meant to extend to everybody so that you don't end up with a second-class set of residents, for example. So, what is the job of a legal professional in dealing with this system? The first is that we can contest the medical assessor's findings. Now, we're not medical professionals ourselves, we don't have the expertise, but we can use the opinions of the applicant's own specialists, point out how they might counterbalance those of the medical assessor. We can also raise the point that the test to be applied is whether there is a relatively high probability that the applicant is going to cost the taxpayer money. Sometimes we see the medical assessors saying that it is likely that someone is going to cost X dollars. However, that is not strong enough, and we have been able to turn cases around because of essentially a fudged assessment. And the next one is whether the condition concerned is in fact a severe condition. You may recall I was talking about some listed conditions needing to be severe before they were deemed to create a not ash situation. The matter of severity is obviously a subjective one to some extent, but if there is objective evidence, for instance, from the applicant's own specialist to argue that the condition is not as severe as all that, then it is possible to turn the case around. We can also argue legal precedent for taking a certain stance on certain conditions. There are decisions of the Immigration and Protection Tribunal on precisely the topic of medical waivers, which we have access to and we try and use quite aggressively to assist our clients. Another thing that we spend a lot of our time doing is to tell the story of the applicant, their family, those around them, and their potential contribution to New Zealand, for example, and to encourage our clients to get together strong evidence and useful evidence which is going to support the account that we give that these people should get residence despite the medical issues that they have. if the application ultimately fails, then we're well placed also to take a case on appeal. We have done so in the past and successfully too, although we don't win them all. This kind of work is exactly what we do. This is what Laurent Law spends its time doing, among other things. And if you are aware of anyone who may need assistance with dealing with a medical waiver or a medical issue that could result in a waiver situation, then get them to contact us. You can find our website at www.laurentlaw.co.nz. You can telephone us on the number on the website, or you can email me at slaurent@laurentlaw.co.nz. Thank you for your attention, and all the best.